Welcome back. In a recent FBI interview, investigators reportedly brought up a topic Hillary Clinton's aide Cheryl Mills was told would be off limits, and both Mills and her lawyer fled the room before ultimately returning to continue the interrogation. So what's with all the dramatics? Only one person to ask. Judge Andrew Napolitano, Fox News senior judicial analyst. Welcome back, Judge.
Good to be with you, Kennedy.
So what a crazy thing this is. It seems we're closing in on the end of the investigation.
Right.
Is Cheryl Mills the second biggest fish next to Hillary Clinton?
Well, the purpose of this interrogation of Cheryl Mills and 4 other of Mrs. Clinton's closest aides when she was the Secretary of State is to find out if those aides should be charged with a crime, will be government witnesses against her, will be defense witnesses in favor of her, or will not have any role in the case. Mrs. Mills hired a very sophisticated lawyer, as did all of them, because they all hired the same lawyer. Questionable ethically, but that's what they've chosen to do.
Is it David Kendall or is it someone else?
No, it's not David. It's not David Kendall. That lawyer negotiated an agreement with the Justice Department. Remember, this is a voluntary interview.
Yeah. So
the Justice Department may say, okay, we'll agree not to ask certain questions. Here's the nonsense the Justice Department accepted, and this is a little troubling. Mills is a lawyer.
Yeah.
She and her lawyer argued to the Justice Department that when she advised Mrs. Clinton, she was Mrs. Clinton's lawyer. Therefore, what Mrs. Clinton said to her and what she said to Mrs. Clinton is protected by the attorney-client privilege. Therefore, the Justice Department and the FBI would not ask her about that. And they agreed to that, except one FBI agent basically said, the heck with this, and started to ask her about the emails. That's when Cheryl Mills and her lawyer left the room with a Justice Department lawyer. They went back, they spoke to the FBI agent, he agreed to stop, and the interview continued. What does this tell me? It tells me 2 things. It tells me that Mrs. Clinton still has some reach into the Justice Department so that she could create this agreement.
And they're reaching into their pocketbooks and donating money to her campaign to the tune of $75,000.
That is reprehensible. Obviously not people that are on this case.
Yeah.
It also tells me this. We only know about the event you and I are talking about because the FBI leaked it. So it tells me when the FBI is burnt, unhappy, or believes the public needs to know, hint, hint, they'll leak.
Absolutely. And, you know, with Bill Clinton coming out saying this whole thing is a game, they've got to be getting frustrated on top of the lines that Mrs. Clinton has been using with the press.
The more he calls it a game and the more she accepts that, the more animated the FBI and the Justice Department are. It is anything but a game.
They're taunting the FBI. Well, let's move to North Carolina together, shall we? And the federal government, they're squaring off in court over the state's controversial bathroom law that requires people to use bathrooms corresponding with the sex on their birth certificate. Now, proponents of the law say it protects women from potential predators, whereas the Department of Justice and ACLU claim it violates the 1964 Civil Rights Act. So who is in the right?
Well,
this whole thing is annoying, by the way. I can't stand this whole thing.
I agree with you. It is annoying. And the answer to who is right will probably be decided by a federal judge. Should it be decided by individuals rather than by a federal judge? Should the city of Charlotte, which started all this, or the legislature of North Carolina, which neutralized what Charlotte did, be telling private businesses how to construct their bathrooms, or should private businesses construct their bathrooms on the basis of the needs of their clientele? But here's what the government claims. It's a very interesting argument. The law is the Civil Rights Act of 1964, prohibits discrimination on the basis of sex, S-E-X, nothing about sexual orientation, nothing about gender identity. Attorney General Lynch says now, in 2016, the word sex means gender identity and sexual orientation, even though on 4 occasions there were proposals in the Congress to amend the Civil Rights Act of 64 to include sexual orientation and gender identification, and all 4 of those efforts failed. So now a federal judge is going to have to decide, should I go by the legislative history, Congress could have done it but didn't, or should I go by the government's creative reading of the statute, this is what they must have meant even though they didn't contemplate
you could make broad interpretations, which we know can get us into a few judicial pickles. And speaking of which, I'm going to go to North Carolina this weekend, and I'm going to attempt to use a variety of bathrooms, and I'm going to interview people.
You're going to have a camera crew with you?
Not inside the bathroom, but outside the bathroom for
people will line up to see you trying to force your way in certain bathrooms.
I will at one point have a fake mustache and a ball gown.
I was just going to ask you how you're going to appear
Judge, it'll be interesting.
Don't tell anybody.
It's going to get real in the Tar Heel state, so
if you need legal counsel, I am not admitted in North Carolina, but I will come down there.
Okay. I will take your email and your cell phone, Judge. Thank you.
All the best.
As always, thank you.